ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಮತ್ತೆ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆಯಾ?
ಕ್ಲಿಯರ್ ಇದೆ ಸರ್, ಕ್ಲಿಯರ್ ಇದೆ ಸರ್.
ಸರ್ ಆಡಿಯೋ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ
ಹಲೋ
ಸರ್.
ಆಡಿಯೋ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಓಕೆ.
I couldn't make it disappear, but honestly.
ರೆಡಿ ಏನ್ ಮಾಡೋದು ಹೇಳೋಣ, ಮಾಡ್ತಾರೆ.
Hello, court officer. Hello. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಓಕೆ ಓಕೆ
ಕೇಳಿಸುತ್ತೆ ಸರ್, ಕೇಳಿಸುತ್ತೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು, ಥ್ಯಾಂಕ್ ಯು.
Fresh matter. Fresh. Ask him. Fresh matter. Responded. We'll check. But yes. Patrick, you did not mention, give it, Mr. We are only, why is it so difficult? We are telling only give court slips in fresh matters. We are granting the date. We are not even pending. So pending means you will get it in preliminary hearing and try to argue. We will not do that. You will get it in the preliminary hearing list and try to argue the matter. No final hearing, we are telling. Not granted any interim order. He has been dismissed. So who has granted the interim order? So why you have woken up just 2 days ago when it was granted? So now when the we will grant you the liberty to move the vacation bench. This is not You should also introspect, Mr. No. August 21, tell us how many months? No, how many months? First of all, August 21, how many months? If in 8 months and you want to burden is only us, why? Vacation bit. No, nothing. Fresh matter. Single bench means what? We are granting all the mentioned memos. We are only telling you don't move it in a pending matter. Why is it so difficult? We are not even asking you. So you are explaining. So that means something is not in order, right? Something is problem.
Such cases, my lord, interim order has been passed, my lord, in this particular matter has not passed.
It is not passed.
SHV matter, my lord, relating to Prorata charge fee.
Ah,
My lord, I filed an application.
when this matter had come up,
My lord,
this was listed.
my lord, in the last week, my lord.
That's
I
why.
filed an application to modify the interim order, my lord. So that, my lord, the honorable judge asked me to move before this honorable court, my lord, that is division bench, my lord. So that I am before
Yes.
this honorable court.
He has questioned the virus. It had come before this.
But he is granted. Single judge is granted
Not
an
question
order.
validity.
He wants
Constitutional
us-
validity, my lord.
Ah,
I am not valid.
not challenge the validity.
Not challenge the validity.
Not
Then how-
challenge.
Then how it will come
you
before this?
It is listed and it is ordered to come before this honorable court. That is
You talk to registrar judicial. You cannot do like this. We are not the district council. Understand that if somebody issues an instruction, some judge to you here to execute that instruction, right? Understand? Tell you to go to a playground here or in the climb a tree. So then other judge will say, no, don't climb, or you climb up to the top. This is what, don't do it. It is registrar judicial, you get it. This whatever.
Judgment of judgment, Sri Gautam Bharadwaj, Sri Jivani Devi.
Find any ground to interfere with the order of the judge.
I am appealing for my lord, 3 weeks, but one submission, my lord. The order is passed by your lordship justice Alok Arad. If the office may be directed not to post before.
So don't
It's all under
grant any
challenge.
time. Let this appeal be listed before a bench in which one of us is not a member.
Sorry, my lord.
It's all right. Why you should be sorry? Yes.
Number 4, Sri V. Anand. Right? Sri Gautam Devi.
2 weeks.
Appearing for appellant in this matter, Lordship. Kindly weeks time may be granted,
Weeks.
Lordship, to comply after the brief.
Number 7. Okay. Sri Nom Secretary RP. Number 10, Naive. Number 11.
One number.
Appearing for petitioner, Your Lordship. In this, we have complied, Your Lordship. Appearing for the petitioner in this case.
It's on 7th June 2021. It's on the compulsory. All other cases, it's not. Trying to tell you, other matters have been fixed for 7th June. Appearing. What is the date? Appearing. We have fixed cases on 7th.
Your Lordship, you are not audible.
You are appearing in which case? On the 11th.
Your Lordship, I am appearing for the petitioner in this case, Your Lordship.
Which slide? List on 7/6. What is 11.8? What direction? Sir Ramesh, who appears for respondents? Decide what direction you want. Cases will be taken up on this thing. Right? Acha. Then 11.8, Mr. Shreya S. Kumar, learned petitioner. He learned respondents 1 to 3. Mr. N.K. Ramesh for respondent 4. Madam, you are appearing for 11.8. So, 1, 2, 3, we have marked your presence, and Mr. N.K. Ramesh for respondent number 4. Learned counsel for the petitioner submits that great petition has been rendered. That appeal of IA 2 of 21 has been rendered infructuous. Upper field clerk, accordingly, same is dismissed. 7th June, 7th. She is there, the council has come. Ask her. 7th June, your matters have been rural service.
Yes, Your Lordship.
In which case? Is the matter about?
Compulsory service.
It is along with WP number 100,000. On furnishing of
Police report received.
police report received,
Served on the father of respondent number 3.
served on the father. Variable warrant was issued.
Yesterday only he received the warrant.
What to do? He has run away with the child and not even permitting the child to meet the mother. So, and tell him that, tell him that he would land in jail. Right now he's sitting wherever he's sitting, but he will land in jail now if he doesn't behave himself. Repeatedly, this is the way. You come here, this side. So what has?
Yesterday only I got the instructions of where in the matter. And I asked him to repair in EC.
No. There's nothing great about it. It is a petition. Wife against you. You have run away with the child. And the child is aged about 8 years. And since how many days mother has not seen the child? 2 months. Mother has not seen the child, 4 months. And this gentleman has run away to Noida. So he thinks that he is above law. This is habeas corpus. During pendency, you will have to produce, ask him to produce the child day after tomorrow.
I am okay. I got it. I filed wakalat.
You have filed wakalat, right? So we are interacting with you. You produce the child day after tomorrow in the court.
He's in Delhi Lordship.
Whatever. Why it is not possible? How much time does it take?
Yes.
How much time? How much time does it take? What does he do?
He's working as a private company.
What private company?
IT professional according to my.
So he can't travel. He travels by bus. Do you want to tell us that he is an IT professional and he walks on foot in the city and travels by bus when he goes to Faridabad or Greater Noida? This is what you are trying to tell us? No, mister.
I haven't got any information about the matter.
So don't appear. Don't appear. If you have no, not appear. Once you appear before the court, you have the responsibility. We are passing an order. Let's see. If he doesn't produce, he will face the music. You don't worry. You have no instructions. We will say in your praise, we will say something that even though you have appeared and filed wakalat, you are telling us that. Why? So also know that what is the effect of engaging a counsel. Mister, don't try to play smart. This is, I mean, you know why you want to avoid it, and you want that it should be taken up after vacation, right?
I am totally planned to this.
So don't appear. If you do not have any instructions, we request you not to appear. He is appearing in person. We will mark his presence. Don't appear. We are not forcing you. We are not forcing you to appear. We will say. Done it High Court government. Whatever. What a High Court government figure. 1 and 2. Respondent number, Mr. Though respondent number 3 has appeared in person. So Muhammad Tahir.
Sir, are you Muhammad Tahir?
Mr. All right. So you don't have any. Though Muhammad Tahir advocate has entered appearance on behalf of respondent number 3, yet that he has no instructions in the matter. Yes, Mr. Respondent number 3.
Yes, sir.
What are you doing? What are you doing?
Sir, मैं IT में हूँ.
What IT?
Software industry.
What are you? Are you an engineer?
Yes, sir.
You are an engineer. Where are you employed?
Sir, I am employed in Noida.
Which company?
Dion Global Solutions Private Limited.
All right. So we are directing you to produce the child day after tomorrow, right? You come to Bangalore along with child day after tomorrow.
Sir, child
there is the direction of the court. If you can't appear, then fine. The consequences will follow. That's what your advocate is doing. Same thing you are trying to do. It's unfortunate.
सर चाइल्ड बहुत डरा हुआ है, वो बैंगलोर नहीं आना चाहता सर, इसलिए
we are asking you to bring the child along with you to Bangalore day after tomorrow. If you are unable to bring, the law will follow its own course, right? Fine. We are putting you on notice that if you don't appear, appropriate orders will be passed. Whatever we can do will be done. Yes. Party in person is directed to produce the child before this court. This respond number 3, who has appeared through video conferencing, is directed to produce the child on which date? 22nd April 2022. So directed to appear along with the child. 22nd April 2022 at 10:30. So 10:30 a.m. day after tomorrow. You have said you have no knowledge. What can be? It's unfortunate.
Not with the classic, sir.
Huh? What?
Without any, I wasn't having any inspection.
No, so that
I'm
we,
not aware about the fact, but Lordship is.
All right, no, no.
I'm the
No.
last person to play any smart.
good. You will go a long way. We wish you all the very best. Don't do it. No. Open. No, you should not do it. You, first of all, what is the mistake you committed? What did you not tell us? That I have yet to file wakalat.
I have not filed wakalat. I have to file wakalat.
So we were telling you all along that if you have filed, you passed an order. That's the end of the matter. It's not on record. It's not on record. What we have said is only with that order.
I'm not done anything which I need to improve. I have always
Fine.
tried to be.
We have not said anything in the order. We have only said that we delete that. You don't appear. So delete is appear. That we have said by way of you are a young man. That is what we expressed. We don't have anything in person against you, sir. I don't even know you. Have I ever met you outside the court? Do I ever know you? We only want to say that you are appearing and saying no instructions. So we are trying to tell him that he has to produce the child. You are obviously not agreeing with that. You are trying to say that I can't produce the child. You said he can't. He said he can't appear. You told us. Then we told that he can travel in plane. How much time does it take? All this you should have told. Yes, sir, he will be present. That's like an officer of the court. Yes, please. Yes. So please. Yes. Mark the presence at this stage. Learned counsel appears and prays for and states that he shall file wakalat during the day and that the directions contained in the order shall be complied. Now happy? Okay. Happy now? We have recorded. Yes. Nothing. It's not a thing, Mr. Courtroom exchanges. We say sometime by way of just to improve. Counsel may be faltering. You should take it in a positive manner. I do not know you. I have never met you anywhere outside this court. Whenever you have appeared, I know. I don't even remember your name. We asked what is your name. So what is it that we are there to? We are not your competitor. I am not going to file wakalat on behalf of respondent number 3. Fine. No, nothing. You should take it in the right perspective. We are not sitting here to. We are strict with these junior counsels because we want the bar to grow. Nothing personal. Otherwise we have recorded it. What is there? There are better things to do, right? Fine. Yes.
Number 14, the Muhammad Mujassir, government advocate.
Yes.
My lord, we have complied with your lordship's order dated 11th March 2022. My lord, deposited the for 40 lakhs of rupees, my lords, in favor of the Registrar General High Court of Karnataka.
Deposited within the time limit, Mr. Shetty. An application for extension.
No, we have deposited within the time limit, but the earlier demand. No, my lord, I don't think it's correct, my lord. We have deposited before 31st March.
In an application, madam, that will be decided. Learned counsel for the learned additional government advocate submits that the demand draft has not been deposited within the time limit prescribed in the order dated 11/3/2020. If you are proposed learned additional government advocate is free to make an application in this regard. Please file.
15, government advocate.
Counsel for this court. Let the rate petition be listed. It went as per roster.
See, the Sudhakar Devi, Balaprakash.
Regarding the legal copy of page number UK, which I am not able upon.
that he is not relying upon page 98 of the petition in view of offensive submission. Office objection is ignored. You supply a copy. Supply. What is it? How much is the amount? 32.
Connected matters are there at 32 and
32 and 33, Mr. Please wait. 32, 33. We will take it up 32 and 33.
Number 17. And a memo to that effect has been filed before this honorable court reporting the death of respondent. Yes, this is matter.
Right.
Husband, respondent.
It will not survive.
It becomes infectious, not.
It says so. It is decree.
I was a attack.
See, the question whether married or not is a question of status. While whether she will be known as widow of somebody or this thing.
And let the appellant take such note. Because the fact that the husband is hurt and not.
You tell us how it becomes any case law, anything. We want to know. We want to. It's a matter of status in law. Whether it, what is the effect of it? It's study. We'll fix it after vacation. Expired. He, however, press warrant is granted 4 weeks time to enable him to make a statement with reference to the case law that the appeal has been rendered infructuous.
18, Sri Manjunath Dev, excuse Kevin Gowda.
Delay 286 days. You have filed objection.
Not filed objection, my lord. Just 1 week is some time after vacation, immediately after vacation.
I have only one request in the interregnum, my lord.
First of all, delay has to be condoned. Then
And the IAD for contact rights is pending. We have an the order from the. So the contact rights have not been resumed. So that can be resumed at least in the vacation.
Part with the delay of 286. Now, this objection. But past what has been period knows what is the court will be the court can come to.
yes, only you know what is the law with regard to delay. We have
Reason is because there was some delayed reason. Affidavit gets made allegation on the affidavit appeared previously. I part the complainant, I mean the petitioner. He also against me when he came to serve a copy. He threw the advance application on my table, and he has come with the camera on his buttons. And now he has got a complaint against before the.
you file of I can't do anything but you file objections to this. How much time? 5 weeks time you file it, will come up in vacation. Correspondent press one is granted a week's time to enable him to file objections. Vacation court, I mean, I can't be heard in finally in vacation, right? Move the court. We have not said anything. We have only said 1 week's time is granted. You move the court. You are required to move an application, right, for hearing assigning to it.
I appear for the appellant, my lord. The office objection, my lord, is only in relation to, my lord, R1, my lord, which according to me is very clear, my lord. So therefore, my lord, at the page. Secondly, my lord, there is a delay. There is no delay, my lord, as such.
There are 3 office objections, sir.
Pardon, my lord.
There are 3 office objections.
Three office objections, my lord. Your lordship kindly see, my lord. One of the office objections is in relation to R1, my lord. R1 is very clear, my lord, according to me. Your lordship kindly see, my lord. It's very clear copy. I shall file one more, my lord. But in the meantime, I'm anxious to see that the appeal is heard because he's 80 years old, my lord. No, he's 80 years old, my lord. Therefore,
objections, kindly comply
that. No, your lordship kindly see, my lord. There is some urgency in the matter. I shall comply with the office. So far as one of the office objection, my lord, is in relation to, my lord, clear copy. According to me, my lord, is clear, my lord.
3 office objections. There are 3 office objections. Please comply that.
My lord, I am only anxious to see that the matter is heard. For preliminary, at least notice is ordered, my lord, because the party is 81 years old, my lord. Therefore, I am struggling to get the matter listed before court.
We are not responsible for the fact that he is 81 years old, right? It is listed for 3 office objections. Please comply. That's what my brother has said. Told you. If you want to comply, we will say.
Well, my lord, I will comply with.
That's it.
Court mic is muted, my lord.
What? Complied. You have complied the office objections, Mr.
Yes, so far as their consent is done, they had to file the objections on IA1.
Why does it say furnishing of PF? When have you furnished PF? Does it say so?
I don't say quarter of 6 4. They have taken notice and they have undertaken to file the
State.
Who is the other respondent? You are the contesting.
File. Right.
Copy not given to us.
Take an she will give you an extra set. There's no problem. You ask her, go through the objection. And it's no. Not, there's no question. It has, you have to be heard and then an order has to be passed. Not what is this? If you don't. No. We will try to blackmail us into passing an order. So, please argue. Yes, please argue. Don't argue. No objection. You are telling us pass an interim order in the meanwhile. How can we ask them to not to precipitate? We will have to hear you, right? We will have to be convinced for grant of stay, just like you are putting words in our mouth, asking her to not to precipitate. We cannot tell her. She will not undertake that. We know it. Ask her. If she undertakes to not to precipitate, we have no objection. We'll list it up. Madam, will you precipitate the matter? We have to then hear, please. Please hear.
Right. 6-4. This argument, there is evidence that appeared in the matter.
Please see.
My lord appointed. My lord said, once the Advocate General says nothing would happen, my lord.
Orally, that is till today. They have filed objections. Please argue now. Please argue.
Sorry, my lord.
There is nothing in the order. No, sir. Supposing if we told, I mean that for your benefit, you should not, Mr. harp upon it, right? I mean, then we will stop then speaking then anything. We told by way of this thing that hey, Mr. Advocate General, don't do anything. So you are taking advantage. There is no order. There is no order of undertaking recording. Please argue. Fine. No, please. We are not sitting here to accept the apologies. Please argue. We are trying to find all of you what you fail to understand. We are all sitting here. We don't have any personal interest in the matter, right? You don't have. We are sitting here to find out the solution to the legal problem. Please argue. Yes, if you are, please argue. What state do you want? Yes.
Anything that I have to.
No, nothing. Nothing.
I don't want that impression.
Nothing, Mr. Please argue. We are asking you to argue. You are still stuck in.
I just make it wants to see the.
What is that? We'll list it tomorrow. We have not read the file, to be honest, because this was for office. We don't go through the cases which are listed for office objection. So we have no idea. So we will list it tomorrow for orders. Learned counsel for the appellant submits that what you don't want to serve respond number 2.
We serve respondent number 2. That's IMA itself.
Submits that the contesting respondent, namely state government, has entered appearance and stop at this stage. Learned additional government advocate submits that she has filed objections to ISO and so. Let the appeal be listed 1 of 22. Let the appeal be listed for consideration of IA 1 of 2022. You said this file, Mr. Tomorrow. Tomorrow or day after? What tomorrow? Tomorrow. That's what we told you in the beginning. She would give an extra set, we told you, but you said that no, it should be extended, whatever. That's why we
What's happening is when in this case, I considered on the application, all my rules are being given away to the depositors. 13.2 crores is already given, so the matter is pending consideration here. That's the anxiety that we have.
all right, though. Please argue. We will hear today itself. We have plenty of time after motion hearing. You argue today. No, nothing. Arey, Mr. You.
Sometimes because we try to express what transpired orally last time. That's our intention.
Fine.
Nothing more than that. Nothing more than that. What transpired orally sometimes it is not in writing.
He recollected, you rightly said, but that cannot be made a ground. We recollect that it happened. We told Advocate General, he appeared, we told him, please do not take action. You were insisting that it should be recorded, but it has not been recorded. Why?
My intention was to say that I'm sorry, anything else has come out.
Not necessary at all. Please, we are here to decide the legal issues, not here to accept. Thank you. Yes, not tomorrow. Yes.
22, the Giridhar Estate.
Permission to file appeal. Yes. Permission to file an appeal, you are not party.
It's again IMA.
This matter, you have got copy. Counsel for the appellant undertakes to supply a copy of memo of appeal along with annexures to learned additional government advocate during the course of the day, this day after tomorrow. 22nd.
23, the Samit here. Bharat Prasad.
Tell us. Where are the orders? Tell us. We are asking you. That's why we are not passing it over. You should have supplied to him. Instead of us, you should have given him beforehand. Instead of supplying it to us. So they have to look into it. What are the that order is there. Yesterday she typed. Right. Your senior. So with so and so, learned senior counsel for the petitioner. Heard on the question of admission interim relief notice on behalf of respondent number 1 is accepted by Ms. Srimati Vani, additional government advocate. Notice on behalf of respondent 1 and 3. You accept 1 and 3, madam. 1 and 3 is accepted by Ms. Vani. Assistant Director, Town Country Planning. BBM. Okay. Yes. A notice on behalf of respondent number 2 and 3 is accepted by Mr. So and so. Learned counsel, Mr. Bhanu Prakash, right? Learned counsel, the senior counsel for the petitioner submits as the rate petition involving similar issue has already been entertained and interim order has been granted. Where is that? In support of aforesaid order, aforesaid submission, Reliance has been placed, order dated. Oh, that's 9/3. 9/3/2022 passed in WP number 654 of 2022. Full stop. It is further submitted that a demand of rupees 1,71 lakhs 10,000 has been raised. Full stop. In view of proposed submission, it is directed that in case petitioner deposits a sum of rupees 30 lakhs. No, 30 lakhs. We are directing 30 lakhs. 30 lakhs, comma, the no coercive action shall be taken against the petitioner for recovery of the balance and the respondents number 2. The petitioner subject to the result of the petition. List along with WP number whatever. Yeah, please. Yes, for remaining amount they will furnish. Where is that order, Mr.? They also don't supply. You do everything except it's there. So, the petitioner shall also furnish indemnity of the payment of the remaining amount in the event of failure of the petition. Shall furnish an indemnity bond within 1 week to secure the payment of remaining amount in the event of failure of the petition. List for analogous hearing along with WP number 654/2020. So he's saying day after. Take it up, madam. Mr. Learned Additional, Learned Government Advocate for Respondent 1 and 2. Mr. M.K. Ramesh for Respondent number 3. Mr. For Respondent number 6. Mr. K.P. for Respondent number 4. Learned Counsel for Respondent number 3 place for short adjournment. List on 22nd April 2020.
Number 25. Electric full time. Government education.
Ullah, it can't be heard. Tell us a date, Mr. After vacation. Any date after vacation. Tell us. We will. Otherwise, we'll mention a date. He will say it's not convenient. That's why we avoid. We are asking for a joint. 31st May, Mr. Ullah. 31st May is all right. Margaret, Lalit Senior Council parties list after ensuing summer vacation on 31st May 2020. Government education.
Marginal.
That was question and interim order. Under rule 30, PDA, now that the PDA is not in the market, right?
The rules, there is a that what for that.
Supply a copy.
Who has appeared for BDA? Who has appeared for BDA? So take notice, Mr.
Take notice in this matter. Take notice on behalf of 1 and 2.
One is government, one is government.
Yes, yes. Learned additional government advocate and Mr. Office is directed to reflect their name just after summer vacation. Why don't you decide his representation? We can dispose of this appeal itself. You decide whether or not he's entitled. That's all he's saying. So, please see the what he says that rule 3. You see, he says under rule 3 is entitled, learned single judge relied on rule 5 and dismissed the petition. Now his prayer is to consider the prayer for allotment of a corner site. Or you seek instructions. We will grant you liberty to move the matter during vacation.
During the vacation.
We have not granted any. We're telling him.
Pending matters normally. So if it is up to 1/3, you can give it.
We'll get what a list for consideration of prayer of for interim leave on 24th May. 24th May. 24th May it will be listed. Yes. Praying for time. Happy presence. Appellant prays for it. Just after ensuing summer vacation.
File it in the registry.
File it. The registry, yes. 28, government advocate. That are doing council is not well list after vacation. Vikram. It's covered for presence interim order granted on earlier occasion shall continue. You want some date? Yes, ma'am. Just after ensuing summer vacation. Number 30. What is to be done? If we can't be heard finally, Mr. Huh? Whatever it is, it will remain in your favor, right? Even after vacation. Huh? Yes, mark the presence, learn it, counsel for the application. That what sketch map?
Village. That's the village mapping.
Layout map of building cooperative society shall be filed during the course of the day after supplying a copy of the same to learned counsel for just after ensuing summer vacation. Any shall continue. 31, Pawan Kumar M.N., government advocate. Passport. He knows what order we will mark his presence. He knows what order will be passed. No, what order will be passed by us? Tell us. Huh? Yes, you are not working with him. Oh, then you should accept this, right? Thankless job, you should accept. What is the total demand? How much you are? Order. Balance amount. Yeah. Have you written anywhere 3 and 4? Whatever. 3 and 4. Huh? Respond number 3 and 4. Same order shall furnish bank guarantee whatever security. Your 16 is also same order.
The amount there, 16.
What is the amount? 16. Huh? 52 lakhs. 52 lakhs. Give it in writing. Where is it? Please give it. 52 lakhs, 82,000. 87,000. 400. How much you are paying? 37 lakhs. 52 lakhs. So 1 4 yes, 8 lakhs.
8 lakhs. So
8 lakh 50,000. 50,000. Within or balance amount. Bhanu Prakash, Council for BBM.
serial number 33. 33 what?
Three. Deposit 7 lakhs at least. 7 lakhs.
Pass on the memo.
To give that memo to them, right? Rather than. Or dispensation of production. 16.8. Laurent Singh Jail, Mr. Jet, Senior Counsel. Senior Counsel for the petitioner submits that the writ petition involving similar issue has been entertained and an interim order has been granted. In support of opposite submission, reliance has been placed on an order dated 21st March 2022, passed in W 5929/2022. In view of opposite submission with a view to parity, it is directed that no coercive steps shall be taken pursuant to C, D, and E till next date of hearing. Liberty is granted to the petitioner to seek modification of the order. This for analogous hearing along with WP number 5929/2022. Then you notice to respond number 7 onwards. Whatever. They responded 7 only. Issue notice to respond number 7 and 1 to 6 is accepted by learned additional government. 35.
I appear for the petitioner's counsel. Lord, this is filed by the association on behalf of the service providers. Your Lordship of the
BEL. Not being heard finally. What judgment is admission only? What judgment you are passing on? Senior counsel is there. He knows. He told us he will conclude less than 10 minutes.
Lord,
it's only admission. Admission. We are not allowing the writ petition. Understand?
Lord, this is a for no, my lord. That is another matter, my lord. Oh, that was another matter. This is different, my lord.
It was there. Statutory force of what? Under which? Before us.
The prayer here is only challenge is only with regard to the notification annexed to A.
Yes, my
Virus of
lord.
the act and rule is not questioned.
There is no act, my lord, there. It is only under some administrative instructions. These are all being done, my lord.
Therefore, it has to go before single judge, not DB. Because it has, Mr. Annexure A has no statutory force, right? These are the terms and conditions of this thing, instructions,
my lord.
general and general conditions of the contract. We don't know
My
whether
lord,
it has any statutory force. If it has no statutory force, then it has to go before learned single judge, not before division bench.
These are all administrative provisions, my lord.
So therefore, it has to go before learned single judge. Learned Mr. Rao, learned senior counsel for the petitioner, fairly submitted that the petitioner has challenged the administrative instructions contained in Annexure A, issued by respondent in view of opposite submission. Let the writ petition be listed before appropriate bench.
That is a, may I request your lordship to have it tomorrow, my lord, since there is some.
Here, we can't say. Please make a mention before the court tomorrow. It may take up.
Very well, my lord. Much obliged.
Thank you. Give that. It's that the writ petition involving similar issue has already been entertained and an interim order has been done. Have an extra set? No. Just see, madam, we'll give it back to her. I had given you that day, Mr. Private Educational Institution. Yesterday only I gave out, day before yesterday. Up 25%. Private Educational Institution. Of submission reliance is placed on an order dated 29th March 2022, passed in WP number 6713 part 2022 in view of opposition. In parity, it is directed. It is a demand notice dated 8/3/2020. It's a read. Reading this is there. Government educate. Sensation of CC of or on IA 1 of 22(2) of the requirement of filing. What is it? To argue, what is it? We have only decided yes. It is listed for admission. Please argue. Imposition of selection criteria. By way of amendment to the schedule of the. Yes, we are hearing. By way of Karnataka. Amendment rules. The extent of excluding technology and journalism from applying to the course of English. Is the minimum qualification prescribed? Hey, Mr. Which For which post minimum qualification is prescribed? Graduate primary teacher language. Graduate primary
Language.
So what has been done by way of what was the previous qualification? No. Tell us. Don't annexure. Tell us. You have read it. Any graduate. Any graduate with English as major subject. So what has been done?
Now they have excluded your journalism and psychology subjects, and they included certain other subjects which are available at page 21. Economics, political science, and geography.
Psychology and journalism. And what else has been excluded?
Now journalism and psychology subjects are excluded.
Excluded.
Yes.
This is what is your challenge. It should not be excluded.
Yes.
Why?
From 1967. Who members
Rule can be challenged as ultra wire, so you know it only on two grounds. They have the power to frame the rules. Now, what is why it is bad? Then how it's fundamental right? What is it?
that rules is contrary to the guidelines issued by the National Council for Teachers Education. National Council for Teachers Education.
It is statutory in nature. The guidelines. Huh? Not there. In my copy from page number 214 straight with 219. Pages are not there. 215, 6, etc. not there. Please see. In my copy, it's not there. Oh. See what is there. Not there. Pages. Right. What should we do? No, but who will prescribe the qualification? Court cannot prescribe. Court cannot prescribe. Then if they have to prescribe, then it's not there, Mr. You have put an extra in a document.
The regulations.
Have you come across that decision of the Supreme Court? We say that the qualification is a matter to be prescribed by the employer. Court cannot interfere under Article 220. Where is it? Have you brought? Where means, hey, Mr. Who will tell us why we should search for you? Okay. It's not there, Mr. Rajshekhar. It's not there. You have seen it. You point out where is there. Where is it? You are telling us concept is there. There is no concept in the paper book. So what to do? You find it. Yeah. Nothing happens. You know what is the law. You know it already. And you bring that case law that it is for this thing, court can interfere. How is it arbitrary, Mr.? How can we decide that journalism is a necessary subject for children to be taught? Not obviously not. Fine. Fine. But is it your case that the with a view to exclude you only it has been it's a like single
Say that you know to exclude me, you know, now that means what's the proper number of applicants are you know applying for the present course. Now, even if they
please place it on record. We'll take it up day after tomorrow. No, nothing happened. Hey, we can extend the time if you succeed. What is there? This court, you have any doubt about the powers of this court? Huh? Article 226, we can do everything. What is there? She will, if you make out a case, they will accept your application. What last date is for others who have not come to the court? They're not for you. You have crossed that barrier of Article 14. It does not apply to you. Last day for the court? My lord. No. we remember that our date of superannuation is at least far off, not in immediate future. All right. So, Mr. Rashid, pays for adjournment. What? Annexure M. Annexure M. List day after tomorrow. Day after 22nd. And bring that case to Mr. Please bring.
admission, number 38, the other means.
Yes.
I appear for the respondent in this matter.
But why? Whom have you sought permission, madam? He's telling us he has not permitted adjournment. So now what do we do? Huh? He's telling us that he has not permitted adjournment. So what do we do now? Where is your file? How please don't appear, madam. This is High Court. Please, we request you. How you are appearing without any file, just empty-handed? What is this? You should have taken anybody's file and should have appeared, right? How can you appear empty-handed? Mr. Yes. No, yeah. See, madam, we want to tell you that we have not taken oath for accepting apologies. The only object is we are trying to waste energy since morning only to instill some sense of discipline in the youngsters. If you don't behave, this institution will be nowhere. If you appear like this, tomorrow, yesterday, one counsel appeared without gown. And today you are appearing without file. What should we do? Tell us, please tell us. Supposing if you are a judge, what will you permit all this? And then we are told that this remark is past and this thing and it is not good for my reputation. So you will tell us, it is not good for my reputation. You don't know, you don't have the brief. Please do not appear. Sit down. We will not permit this. So this will set another new law in the profession. Like you can appear before the court without any brief and get away. Don't, please sit down. Please move away. Mr.
The appellant's counsel
we'll take it
called me
after,
very well.
After vacation. None for the appellate. None for the appellate. Mr. Govind Raju, L. Learned Counsel for Respondent. Mr. Ajit Kalyan.
No, I'm Govind Raju.
Mr. Govind Raju, L. Learned Counsel for Respondent. Office is directed to delete the name of Ajit Kalyan list after ensuing summer vacation. Waiting appearance of counsel for the appellant list after ensuing summer vacation. Do anything. Yesterday you noticed she was appearing with the exam. Without. So they will, if you don't stop them, they will come here and say from there in your ears that you adjourn the case. What? The whole purpose sanctity of this court has to be maintained.
Thanks. Okay. Yeah.
Yes. What is appellant? Author not there. Yes. Vacation. This after ensuing summer vacation. What is there? What is happening?
First, at your instance, you cannot say that it is without authority.
It will happen within 1 month, right? It has already happened. No undertaking. No, we will have to hear. We cannot force him to give an undertaking. He is telling for your benefit. All right, please, we'll hear it then. Argue. No, if you want a stay, you will have to argue. We can't by adjourning the case. We cannot force him to. Just 1 minute, one. We hear you.
I have not prepared the award to the. But in the recognition also, there is no case of additional time. I have sent the file of rectification. Even in the case of rectification, I not only arithmetic or other mistakes can be corrected, cannot review and pass and enhance. Power of review for special and exceptional is not.
Right about, was it question?
Get of that award, even if it is void, if it is not challenged, it binds the parties. Mr. 96 volume 1 is CC 435. That's all. Anything else? You say that this award is void, right? That's all. No power.
No.
Fine. What is CC 43? That's it. Anything else? Right. Yes. Right. What are the communications with the 7/6/2017 and 13/6? Very good. Why are you seeking this? It has been quashed. What is it? What has been quashed?
Communication is that the.
Which page? Which page?
At page 225, annex G. The appellate and the respondent number 39 here. Claim to accept the supplementary award. The award is passed by the competent authority. The beneficiary is having two options.
Yeah. It has returned the supplementary award.
Yes.
Both by both communication.
Yes.
So what is your submission?
They said that it is unacceptable. So that is the communication. When once award is passed, the two options are available to the beneficiary. The appellate has passed. Now even the mathematical is filed. Have filed a couple of and the project director is challenging. To the award hard to.
That's what we have to. That's what it was asked to him. He is not challenged. He is happy. So why should you enlighten him on this? Fine, in this petition, in this intra-court appeal filed under Section 4 of the Karnataka High Court Act, the appellant has asserted the validity of the order dated 19th July 2021, by which a writ petition filed by respondents number 1 to 37 has been allowed, and the communications dated 7/6/2017 and 13/6/2017 have been quashed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that respondents 1 to 36 are were the owners of the land. Full stop. Their land was acquired by the National Highway Authority of India for construction of a highway, for widening of a Bangalore-Mysore highway. Full stop. Bangalore-Mysore highway. Full stop. The land acquisition officer, full stop. The special land acquisition officer passed an award on 27/3/2017. And the same was forwarded to the project director NHAI for approval. However, the special land acquisition officer realized that there are mistakes, errors, and omissions, as well as discrepancies in the award dated 17/3/2017, 27/3/2017, the special land acquisition officer by a communication dated 3/5/2015, 3/5/2017, requested the project director, National Highways Authority of India, to return the award. Full stop. The respondent number 2 thereupon returned the award by communication dated 27/3/2017. The respondent number, the special land acquisition officer thereafter passed an award on 25/5/2017, terming it as a supplementary award. Full stop. Paragraph. Thereafter, by the communication dated 7/6/2017, and 13/6/2017, comma, the National Highway Authority, what project director, the project director, National Highway Authority of India returned the aforesaid supplement part, aforesaid award dated 25/5/2017, passed by the Special Land Acquisition Officer. Full stop. The said communications were challenged by respondents 1 to 37 in the read petition. Learned single judge, by an order dated 19th of July 2021, has 19 July 2021 has 19 July 2021 has quashed the communication dated 7/6/2017 and 13/6/2017. Full stop. In the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the appellant submitted that once an award is passed by the land acquisition officer, comma, the land acquisition officer becomes functus officio and has no authority in law to pass the supplementary award. Therefore, the learned single judge ought not to have quashed in the communication dated 7/6/2017 and 13/6/2017. On the other hand, learned counsel correspondence 1 to 36 submitted that 1 to 37, whatever. 37 submitted that no challenge has been made by the appellant to the award dated 25/5/2017, and therefore the aforesaid award binds the respondent. Paragraph. We have considered the submission made on both sides. It is right law that even a void order operates inter parties until unless it is successfully challenged by a party to a higher forum, in a higher forum. In this connection, we may refer to decision of the Supreme Court in state of Kerala versus state of MK Kannan. This is there. 1996, Volume 1, SSC 435. Full stop. Admittedly, the appellant has not assailed the validity of the award dated 17 whatever 25/5/2017 in any proceeding. Full stop. In the absence of the challenge to the award, the same binds the appellant. Full stop. Therefore, the project director, National Highway Authority, would not have returned the award by communications. The award passed by a competent authority by communications dated 7/6/2017 and 13/6/2017. Paragraph. For the aforementioned reasons, we do not find any with the order passed by the result. Appeal fails and is hereby dismissed. Liberty, you are National Highway Authority. You have been engaged. You have been engaged by You have been engaged by National Highway Authority, right? Why we should advise you what you should do? We don't. You are there to advise your clients. Right? You may advise them to file SLP. You may advise them to challenge the award. Whatever, it is up to you. See, you insisted you wanted a stay. We heard you. Arguments, we have passed an order. That should be the end of the matter. Challenge now. Everything goes to, for your convenience, we will sign the order today itself. Today evening, go to Delhi. Make a mention. Fine. No, nothing. Not our job. We have done it. You insisted that it should be heard. We have heard it. Order has been passed. Thank you. Wrong with the order, Mr. Where is that? Which ground you are taken?
Held sufficient.
Nothing happens. There is no vacation there, right? What is happening? 1 month it does not. We have not come across, Mr. We have been, please, Mr. Surala, we have been hearing appeals. None of the appeals or none of the cases have been decided by the Real Estate Regulatory Authority within 1 month. That we can assure you that it will not be decided. Let issue emergent notice list for consideration of prayer for interim learned counsel for the appellant submits that the impugned order has been passed by the Real Estate Appellate Authority without affording an opportunity of hearing to the appellant in view of, in as much as the appellant was not served with the notice of the proceeding. In view of aforesaid submission, issue emergent notice list for consideration of prayer for interim leave on 24th May.
Okay. 42.1, I appear for the review petitioner. I appear for the review petitioner in 42.1.
Justice Sanjeev Kumar is the member, right? For the appellant prays, petitioner prays for adjournment just after entering submission. For hearing issue. What marriage dissolved? Not dissolved. Dissolved. Section 9. Oh. Appeal is admitted for hearing. Issue notice. No, issue notice, right? Don't admit it. Issue notice on that B as well as IA 1 of 2022. What? What? Huh? You have been set free. Dismissed. Oh. Yes, sir. Notice on admission IE. Records would be 3 also, 44 also. Yes. Notice. 9. Okay. The appellant, even when matter is called in second round, Mr. Ajay, Mr. Ajay Are from this. Very wide. Then, in view of none has appeared, so and so in view of order dated 10/11/2021, comma, the amount as directed by this court has not been deposited, comma, passed on IA1 of 2019 is recalled. Let the appeal be listed for consideration of IA number 1 of 2019 after ensuing summer vacation.
The regroup number 46.
The district government advocate Grace Current is granted 3 weeks time to enable her to file the objection.
7. The advocate who
Okay, all right, you know that. 147 you don't know, 148.
Milord, I am for 47.1,
Last
Milord.
matter. Three notifications, Milord. 31 3 notifications.
47 and 47.1 are covered.
Yes, Milord. Yes, Milord.
What he's saying is
Third one.
court officer is saying it's not covered. You are saying it's covered.
Milord, 47.1 is covered, Milord. It is yes, Milord.
Fine, disposed of.
Published, Milord.
40. Advocate. They are helping us by saying you are trying to tell us no, it's not covered. You will write then.
That's why.
No. But they are right. Disposed of. Yes, we have passed an order. Yes, day before yesterday. Notice has been quashed, liberty is granted to them to proceed in accordance with law. Fine. Yes. Receive the copy. Approve this statement of objection. We have not gone through it. But Mr. Ramesh, what happened is he had taken admission in BDS course. He participated in the counseling. No, he had taken admission in the BDS course. Thereafter, he participated in the counseling for MBBS. He was asked to produce the documents on 29th March. He did not produce. Then what happened? Permitted. You are not permitted. Not permitted.
At that time, it is not rejected. Then they can come in the queue later. That is not.
Rejected means come in the queue means who will come? What queue?
This is not offline application. Some serial numbers going to the so right is one slot. The end of the slot will otherwise it will jeopardize the next candidate who might be wishing to take. That particular not given. If they are gone,
is a counseling process, so we can't hold a seat for a particular student. If there is-
Now he has missed the bus. He can't. The question is not open.
That's it, which is.
What is the admission? Admission to MBBS course. All right. Yes, please. But decide in a rate petition, right? This question. Go before admission overseeing committee. No. Admission overseeing committee. Huh? The fact can also be adjudicated, probably, which we may not be in a position to do in a summary proceeding. You can reduce material that you are not permitted, so and so. Huh? So, counsel for remark their presence, learned counsel petitioner submits that he be granted the liberty to withdraw the. Oh, not why? Wait. Huh? Well, doctor. Oh, no. All right. We'll pass an order. Thank you. Order is passed. This thing. So, see, all right, mark the presence in this petition. This petition, the petitioner inter alia seeks a writ of mandamus directing the respondent number to allot MBBS course seat of the medical colleges by verifying the certificates of 10th and 12th standards of the petitioner. Facts giving rise to filing of this petition briefly stated are that the petitioner participated in the first round of counseling, and as per his merit, her merit was admitted to BDS course. Thereafter, the petitioner participated in the mop-up round of counseling for admission to MBBS course. Full stop. The on 29/3/2022. Full stop. The petitioner was asked to produce the original documents. However, she did not produce the original documents. Therefore, the seat could not be allotted to her. In the aforesaid factual background, the petition has been filed. Paragraph learned counsel for the petitioner submitted that one Yashaswini Kurubar has been allowed to select a seat despite despite not having produced the original documents. Full stop. The aforesaid averment of fact has been denied by the Karnataka Examination Authority on affidavit. Full stop. The matter requires adjudication of disputed questions of fact, which cannot be done in a summary proceeding under Article 226 of the Constitution of India. In the fact situation of the case, we deem it appropriate to dispose of the writ petition with the take recourse to admission overseeing committee with regard to her grievance information. That's all. With the aforesaid liberty, the petition is disposed.
Number 49.
For the appellant in this matter, please, Your Lordship.
Yes.
This is a petition, divorce petition filed by the husband, which has been dismissed, please, Your Lordship. On that, the appeal is filed. This matter, more than 20 years of separation, admitted separation is there, please, Your Lordship. The marriage took place in the year 2001. She conceived, she had a child, separation, everything is in 2002. And till date, they have not made any attempt to reconcile or come back together or anything, please, Your Lordship. And even if the many times compromise talks were held even before this court, mediation center, neither they come together nor they leave each other, please, Your Lordship. That is the position of the case. My humble submission is that it would serve no purpose in keeping the marriage alive after 22 years, please, Your Lordship.
Ready
And
to join them.
My lords, initially itself, all efforts were made, please, Your Lordship, because the child was small. They were newly
They
married.
are ready. You have not taken them.
No, please, Your Lordship, it is my only submission is both are very good persons. There is no dispute about it. It is like two very good dresses, but they don't fit to the person who is having it. That is all is the case. And both have got egos, please, Your Lordship. It is not that I'm arguing on behalf of my client or something like that, please, Your Lordship. Only ego has played the role in their life. They have spent 22 years in the court, please, Your Lordship. I would take Your Lordships to the pleadings and the cross-examination. The wife also feels that the husband is an introvert. He is not as bold as she is, things like that. This person feels she's more bold, she's forward, and he cannot adjust. This is the problem with them. This is the pleading, this is the evidence, this is a cross-examination, please, Your Lordship.
Was it not referred to mediation?
It was done many a times, please, Your Lordship.
Why it failed?
They say, the wife says she doesn't want to give divorce. The husband says, I don't want to live. That is all. It comes back. And not even one effort was made. Admittedly, in the beginning, whatever she says, she went for the confinement. So she did not come back as per the rituals. He had to call. All that well said and fine, please, Your Lordship. After 22 years, today seeing back, not even one attempt also was made by the wife to get back to the husband. Not one attempt or serious attempt was made.
Why do you say that no efforts are made? Admittedly, you are not taken back her.
He says, you did not come and take me as per the rituals. Because I had gone for the confinement, you had to follow the rituals, come and take me. Legal notices were issued, exchange, even there, the standards like that. You come, take me as per the rituals. It is like so many water has flown now. Seeing here, I handled the case right from 2001, please, Your Lordship. I have also aged along with my clients. Seeing back, I see all those stands I had taken, what is established in the cross-examination after 20 years has got nothing in the life, please, Your Lordship. I have spoken to the counsel on the other side. All efforts, please, Your Lordship, all efforts in this case have been of no effort. No purpose is served. That is the reason the matter is pending for so long, please, Your Lordship. It was before Your Lordship also on many a times. That is before this court also on many a times.
What can be done?
My lords, as per the division bench of this High Court. Pardon, please.
Why you are not joining in?
My lords, according to my client, it is like there is a total mismatch in the relationship. They cannot live together. And I would take Your Lordship to the admitted as far as those things are concerned, she admits. She admits that he's an introvert, he doesn't mix with people. That is what she says. He says she is very bold, I can't adjust with her. Para 6 of the affidavit of the respondent, please, Your Lordship.
Age of the daughter, 20. Working or studying?
The child, even the child,
what is your client doing? He is employed.
She is well placed. In fact, my client is not placed. He is working he is less educated than the respondent. And he is working as in some printing press, he is working something and he has gone astray, in fact. May I read, please, Your Lordship, the respondent evidence at para 6 affidavit, please, Your Lordship. The feeling that the respondent has got towards the petitioner, please, Your Lordship, that is the appellant. And para 11, please, Your Lordship.
Sorry, for the reason that 20 years you have been residing separately, that cannot be a ground for separation, madam.
My lords, I am not
You have-
disputing as
you have not taken him back, taken her back.
my
Therefore,
lords,
you cannot say for your fault there should be a divorce.
my lords, I am not saying that. I admit that I have not taken back, but I made a
You have not
submission
taken back,
without
then you
where
cannot say that. Yes, yes.
I have made the submission without going to the merits of the case, please, Your Lordship, without addressing anything that is established in the case.
Power is not with us.
Yes. On that
That
ground,
power is not with us. That is under Article 142 by the Supreme Court.
My lords, this
You
honorable court
you
is,
have to make out a ground.
my lords, then I would address the case on merits, please, Your Lordship.
Yes, yes.
Please, Your Lordship. The main contention in the petition is, please, Your Lordship, as I've already made a submission that they did not have respect for each other, and she considered him as an introvert and she did not respect him, and she even did not inform the child's birth to him. She did not cooperate with the husband on the day of that is the first night. She did not even cooperate with the husband. And these things are established in the cross-examination, please, Your Lordship. I would directly take Your Lordship to the respondent's evidence and the cross-examination of the respondent, please, Your Lordship, and then to the judgment of the trial court, please, Your Lordship. Para 6 of the respondent evidence. I state that after the marriage, what I experienced was an avalanche of negligence, stubbornly attitude, distrust, and fastidiousness on the part of the petitioner. The petitioner, for the reason unknown, suffered from a syndrome whereby he never interacted with his parents and other family members, and me too. At home kept very reserved, and he never used to take me to any of the relatives' house. When questioned, he used to flare up and mention that his relatives were not good people and all of them would demand money, and therefore he wished to sever all ties. I state that prior to the marriage with the petitioner, there was love lost between him and no love lost between his sister and brother-in-law. He was not in talking terms with his parents as well. This continued after my marriage too. The brother-in-law of the petitioner had a bitter experiences interacting with the petitioner. These two things I have demolished in the cross-examination, please, Your Lordship. I state that the petitioner has not bothered to discuss about his business, has not shown his business premises and things like that. Turnover, she doesn't know, and he did not discuss the performance of the business. This is what is stated in para 8. Para 9, please, Your Lordship. I state that the petitioner used to get unruly wild for the smallest reason. An incident that occurred during my pregnancy is worth narrative. When I was 3 months pregnant, I had sickness, nausea, vomiting. When I returned back from the work, despite of my difficulties, the petitioner insisted me to cook food. When I pleaded inability, he screamed at me, claiming that I was not only the woman on the earth who was pregnant, he called my mother and threatened her, and that he would not be responsible if he did any harm to me and if something happened to me, and later back the phone. Another instance, these are the instances she gives. Para 11, please, Your Lordship. And the para 10 is also important. Another instance during the pregnancy was that though the doctor advised against me traveling my 3rd month, the petitioner insisted that I traveled all the way to Haveri. At Haveri, my grandmother in her casual talks asked whether we have adjusted with each other, which arose suspicion in the petitioner, and on return he made an issue telling that we have hidden something before the marriage. That is why Granny was asking like that. When we returned from Haveri, my health condition worsened. I had severe stomach pain, which I reacted for by telling that he couldn't do anything about it as he was not a doctor. Another instance during my pregnancy was that the doctor had advised me against the intercourse since my possessed blood group is O negative, as there were chances of abortion. This also is established in the cross-examination that it is false. The petitioner was physically present when the doctor advised both of us against indulging in intercourse. Despite this, the petitioner forcibly wanted to have the intercourse, claiming that the doctor knew nothing and that he knew everything. And when I insisted them, explained to start shouting that he was no doctor to know. I was shocked to realize the indifference words of pregnancy. I state that the petitioner is also suffering. This is again what she feels about the petitioner, please, Your Lordship. I state that the petitioner is also suffering from severe inferiority complex, and this was evident in all his traits, actions, and behavior. The petitioner had hardly any friends, and the petitioner chose to remain so. I always used to encourage the petitioner to shed his complex and be bold and outgoing. It is perhaps this that has irked the petitioner in filing this petition. I state that the pregnancy was a joint decision of both of us, and therefore I expected the petitioner to respond likewise as responsible parent. All his contribution in the whole period has been none like any other woman. I had expected the moral by moral support by him. Instead of that, he even has not bothered to ask me once how I was doing. He never showed any concern to me or the child. He never brought any fruits, medicine any time during the period. All I asked him once was why I have choose all he asked me once was why I have chosen expensive doctor and a hospital. After completing all the rituals, I left for confinement with the consent of the parents of the petitioner, since the petitioner was not present at the function, which he knew in avoidance and chose to stay away. This again I have established in the cross-examination that it is false. She did not leave the house for confinement. On the other hand, there was a fight between the petitioner and the respondent, and she left the house without the consent of the petitioner. It is also borne out by the letter written by the father of the respondent to the petitioner, which is marked as Exhibit P6. May I please, Your Lordship?
Yes, madam.
The petitioner never bothered to visit even once, let alone show her love and affection towards me and the child. Even after the delivery till this day, the petitioner never bothered to visit the child even once. The brother and the parents of the petitioners also failed to visit the child and welcome the newborn in spite of being in the joint family. When the brother-in-law of the petitioner inquired them as to why they did not visit, they claimed that the petitioner had warned them against the visiting or seeing the child. It is established in the cross-examination that she did not even inform the petitioner's house that she had given birth to the child. It was a premature delivery. They were not aware till many days, till nearly 1 month, they were not aware about the birth of the child. Once I was requested by my cousin to accompany her to the new house. About para 13 and 14, she's again, please, Your Lordship. I state that during the marital life, I was dutiful, cultured, and obedient petitioner to the petitioner, and the family used to do all the household chores myself. I said that I also used to participate in program in radio and earn an employer of the Global Trust Bank. I state that during my marital life, I have found the petitioner to be an insensious, uncultured, insecure person who used to get annoyed. My lords, they were married only for 3 months, my lords, by the time the petition came up. And nowhere she has stated a little bit of respect for the husband, let alone not as a husband, as another human being, please, Your Lordship. As another human, and it is not my words, it is her affidavit, please, Your Lordship. When such is the situation, how can a person live with a person who treats him like this? This is the main allegation of my client, that she did not respect him in any way, because she was bold, she was working, she was earning, she was more bold and whatever it is. And this person, he was a sober person. He was not an outgoing person, but she was an outgoing person. It was a total mismatch of the relationship. And he had to suffer because of the mismatch of the mindset. And the cruelty is only, allegation made of the cruelty is only mental cruelty. And the second thing is that non-cooperation with him with regard to the sexual aspect. That the Honorable Trial Court has held that On the first day itself, why did he not cooperate and all that? For that, the court has held the explanation because of the mismatch of the blood. Maybe they did not have the sexual relationship. That is how the trial court has tried to explain the what is established in the cross-examination, please, your lordship. That is the reason at the threshold I made a submission. After 20 years, looking back at all this, these things feel, it is like after 20 years, these things have got no meaning, please, your lordship, because now he is 56 and she is 50, please, your lordship.
Got a daughter.
Yes, please, your lordship.
Yes.
And I have seen the daughter, please, your lordship, during the conciliation or mediation. The girl has been brought up in a very good way, please, your lordship, in a very cultured manner. There is nothing to say about that. The mother has brought up the child in a very good manner. Though I appeal for the husband, I make my submission that she has been brought up in a very good manner. She has been taught all cultural activities. She is good in swimming and so many other things. That is not disputed. She, as a mother, she has done her duty. She has brought up the child in a very good way. The only problem with these two couples is the ego, and there is a total mismatch. 14, please, your lordship. I state that during my marital life, I have found the petitioner to be an insensuous, uncultured, insecure person who used to get annoyed at the drop of a hat. That is the reason, please, your lordship. My submission is from the threshold, this is how she has treated the husband. From the threshold.
She has not stated in her statement of objection.
She stated, please, your lordship, she accepts that you have, my lords.
Statement of objection, she clearly says that she has got so many things to say, but she will not say at that stage because chances of reunion will be not there. That's what she says.
Yes, please, your lordship. But I will also draw the
attention
attention of the
anything.
court.
It is only at the stage of evidence. To save her case, she has said everything.
Oh, please, your lordship. May I take your lordship to para 2 of the written statement, please, your lordship?
You read para 13.
I thought before, when denying my contention at para wise, she has stated, please, your lordship, para 2 of the written statement.
Denying what?
When whatever is stated by the petitioner in the petition that she has stated, and while denying, she has also admitted that she what are the feelings she has got towards the petitioner, please, your lordship. Para 2, please, your lordship. Insofar as the averment at para 7 and 8 of the petition are concerned, the same seems to be preamble to buttress and the alleged innocence of the petitioner, which, however, is not true and correct. The petitioner seems to have lost sight of the fact that the petitioner is entitled to expect the same amount of happiness, mutual love and commitment from the marriage. This respondent is thankful to the petitioner for admitting that the petitioner had a personal interaction, whereat he found this respondent to be very bold, more than matured and expressive. And my lords, what I'm trying to say is that other than, however, the petitioner is, the respondent is more bold, more interactive, and more forward, please, your lordship, than the petitioner. That is what is stated in the petition, which she says, I'm thankful for the petitioner that she has admitted my qualities. That is the respondent qualities. And
what is the ground of cruelty, madam? You have to establish what is the cruelty and where is the desertion.
That's my submission is.
What is the cruelty?
Cruelty is mental cruelty, please, your lordship. Treating him in a mental cruelty, treating him in a very bad way, not respecting him in any way, not allowing him to have continuous or proper sexual intercourse with her. And the last thing,
have a child, how you can say that there was no proper intercourse?
Yes, please, your lordship. That is, I have not that he did not allow her at all. Only once or twice they had sexual intercourse. That is what is stated in the petition. And she does not, in so many words, deny it. But in the cross-examination, it is established even in the first night, she did not allow him to touch her. 3 different reasons are given to say that why she did not allow him to touch her. And the last is that when she left the house, she claims that she has gone for the confinement, which is also not correct, because they had a fight and she has left the house, which according to Exhibit 6 of the father who has written the letter to the son-in-law saying that I will try my best to sort out the issue between you people. that itself shows that nothing was proper even when she left for the confinement. But she claims that she left for the confinement and we had to go and get her back. But the letter of the father, which is marked as Exhibit P7, which she does P6, which she does not deny, clearly shows that they did not have a proper relationship from the threshold. And he in fact says, father in fact says, I will advise my daughter that she has to correct herself. That are the wordings of the father's letter, please, Your Lordship. That is marked as Exhibit P6, please, Your Lordship. Since this letter is in Kannada, I am not reading that letter, please, Your Lordship, but it is marked as Exhibit P6, please, Your Lordship. May I please, Your Lordship, shall I read the Kannada version of the letter?
What letter is that? Who has given?
Father has written to the son-in-law, please, Your Lordship. That is, the girl's father has written to the son-in-law, wherein it is clearly stated that she has left the house without the consent of the husband and not as she claims after Srimanta. That is a ritual which is done to send the wife to the father's house. That was not
What is the effort made by you to bring her back?
That is what I'm making my submission. My submission is my client had gone to the house to call her back. She says he did not come back to call her. That is the reason I made a submission that she also did not make any efforts to come back.
Where have you said in your petition or in your evidence that you made efforts to bring her back? There was any panchayat.
I have stated in my petition. I have stated in my petition.
What have you said?
I have also sent a legal notice asking her to come back. I will come at such and such a time and come and take you. I got the reply after filing the petition, please, Your Lordship. I have further examination I have done and I have filed those 2 documents also before the court, please, Your Lordship. Para 14 onwards, please, Your Lordship, where the child is born and all that. The petitioner submits that the respondent delivered a child at Divakar's hospital at Bangalore. Unfortunately, the same was not disclosed to the petitioner either by the respondent or her family members. However, the respondent informed the petitioner after 1 month, 20 days after the birth of the child, but the respondent prevented the petitioner from seeing the child. In fact, the petitioner was eager to show her the love and affection towards the child. The respondent made it very clear from the conduct, resulting in countless bitter experiences for the petitioner, that she would not be a good companion. The respondent did not turn to the matrimonial home, nor gave any indication of returning back to the house. Hence, the petitioner was constrained to issue legal notice dated so-and-so, calling upon the respondent.
Therefore, no efforts made.
No, please, Your Lordship.
Legal notice.
No, please, Your Lordship. In the legal notice, I have stated that I have come to the home.
That is the efforts earlier to that. You have straight away issued legal notice.
No, please, Your Lordship. In the legal notice, I have stated.
No, the legal notice also you called upon the respondent to join the petitioner at the matrimonial home by giving advance intimation.
So that he can make a necessary.
So that he can lock the door and go.
No, please, Your Lordship. To make necessary arrangement to receive the child, because the child was a newborn child.
You have never, not even gone to the hospital even once. You have not said, I went to the hospital after the mother gave delivery.
I have not, in fact, I have not gone to see the child, please, Your Lordship.
You have not said, you have not said in your petition.
I have not gone itself, please, Your Lordship. The mention of
That
mentioning.
shows your conduct.
No, please, Your Lordship. My humble submission is, everything was not good at the time, at the first instance when she left the house itself, please, Your Lordship. When she left the house itself, everything was not fine. That is the reason she also did not inform me for more than 1 year, 1 month, 20 days about the birth of the child. May I read the letter, please, Your Lordship? The father's letter to the son. That is Exhibit P6.
In Kannada.
That is the reason I am not reading it, please, Your Lordship. It is in Kannada. ಈಗ 7 ತಿಂಗಳು ತುಂಬಿದವು. ತಮ್ಮ ಮನೆಯಿಂದ 1.5 ತಿಂಗಳ ಹಿಂದೆ ಅವಳನ್ನು 7 ತಿಂಗಳು ತುಂಬದ್ಮೇಲೆ ಶ್ರೀಮಂತ ಮಾಡ್ತಾರೆ. ದಟ್ ಎವ್ರಿಥಿಂಗ್ ಎವ್ರಿವನ್ ಇಸ್ ಅವೇರ್. 1.5 ತಿಂಗಳ ಹಿಂದೆನೆ ಕರೆದುಕೊಂಡು ಬರುವಾಗ ನಿಮ್ಮ ಸಂಸಾರದ ಜೀವನ ನಿಮ್ಮಿಬ್ಬರ ಸೌಹಾರ್ದತೆಯುಕ್ತ ಹೊಂದಾಣಿಕೆ ಆಗುವವರೆಗೂ ನಾನು ಪ್ರಯತ್ನಿಸುತ್ತೇನೆ ಹಾಗೂ ಕಾಯುತ್ತೇನೆ ಎಂದು ಹೇಳಿ ಕರೆದುಕೊಂಡು ಬಂದಿರುತ್ತೇನೆ. ದಟ್ ಶೋಸ್ prior to 7 months, that is when she was 5.5 months pregnant only, she left the house and the father took her back saying that I will try my best to see that you both get together properly. This very sentence shows that nothing, all was not well even before she went to confinement.
Was this letter issued?
It was written and handed over, please, Your Lordship. It was not written and sent. It was handed over to the son-in-law. And the respondent does not dispute.
What is the date, madam?
Date, please, Your Lordship. It is 18/4/2002, please, Your Lordship. 18/4/2002.
Yes.
It is in the center of the diary.
Letter, the father has clearly said that he will come back to your house along with the daughter.
Yes, please, Your Lordship, but nothing of that sort happened.
Where was the occasion for you to issue a legal notice subsequently? Legal notice issued.
Legal notice was issued much after that, please, Your Lordship. After the child was born and after much after.
In spite of the father saying that they are ready to come back, you did not take a.
He did not say that, please, Your Lordship. He said, I'll convince, I'll try my best to.
You have not read the letter completely. He says that.
My lords.
ಕಾರಣ ನಾಳೆ ನಾನು ನಿಮ್ಮ ಮನೆಗೆ ನಾನು ಹಾಗೂ ಈ ವಾಣಿ ಇಬ್ಬರು ಬರುತ್ತೇವೆ.
They did not come, please, Your Lordship.
You have clearly said that we will come.
Nothing has that sort has happened, please, Your Lordship.
They clearly informed that tomorrow, next
But
day they will
nothing
come.
they did not come back, please, Your Lordship. Nothing of
Where is that,
no
madam?
much.
Where is that? Where have you said it? Where have you said that?
Para 9, we have explained as to Exhibit P6, please, Your Lordship, in our affidavit. And para 11, I have stated how I visited her during the pregnancy, please, Your Lordship.
Related any specific incidents of cruelty, either in your petition or in your evidence?
It is stated, please, Your Lordship. I will take your honors to Your Lordship to para 7, please, Your Lordship. Para 7 of my affidavit. However, my dreams and hopes for happiness were shattered on the first day of the marriage itself, when the respondent did not let me touch her even on an official line. My experience during the honeymoon was horrifying, as the respondent had created appalling situations where many of the visitors mistook my relationship with the respondent as something else. The respondent never treated me as a husband, nor conducted herself as a wife, if not for herself, at least for the consumption of others. In fact, when I made efforts to get the much-awaited pleasure of honeymoon, the violent respondent reacted in such a way that I just escaped from being beaten up by others. Now I even fear the mention of the expression honeymoon and, of course, its experience. Para 8, please, Your
And
Lordship. The
that
respondent,
ground is no more available for you now. Because the couple have a child. The experience of honeymoon, first
my
night,
lords,
etc.
my lords,
virtually
my
infectious now.
my lords, one instance of intercourse has resulted in the child's birth. And after that also, she gives the medical reasons and she did not allow him to have the sexual relationship at all. Again, para 8, please, Your Lordship. The respondent has developed an aversion and deep hatred towards me, which was reflected in all our sexual and other romantic encounters which I had with her. The respondent
was whether you have given any specific incidents of cruelty where she has treated you with cruelty. These are all statements, madam, that she has treated you. Single incident you have narrated.
Para 9, please, Your Lordship.
General in nature, all general.
Yes, please, Your Lordship.
All general.
And my lords, they lived only together for 1 month, please, Your Lordship. 1.5 months, please, Your Lordship.
That would have been a ground if the couple did not have a child, but that cannot be.
My lords, I am not saying that they did not have intercourse at all or they did not have sexual relationship at all. They had the sexual relationship once or twice. And the respondent, the petitioner has never denied the child. He admits that it is his child.
For now, the child is of a marriageable age. He has got responsibility for marrying her.
My lords, they have not interacted at all. The father and the child has not at all interacted for the last 20 years.
You have refused to take back them. You have refused to take back them.
My lords, they have not even seen each other. They have not met each other except during the conciliation once. Only once during the conciliation, the father and the child have met each other.
Have you made
my lords, if it is taken that yes, I have done a mistake, it is I did not go, I did not get the child, I did not see, I did not, yes, everything is there. I have not said anything false in my affidavit or petition, nothing, please, Your Lordship. It is plain and clear. We lived only together for few days, few months. And during that period also, there are so many things that has transpired. And it is not that she says, no, I am very nice person, I am that, I am this. She also says she is not compatible with the husband because of so many other reasons. That is the reason at the first instance, I made a submission. Both are good, both are very good dresses, but not fitting to each other. There is no comments about each other at all, please, Your Lordship. She is brought up in a very different way. She is very bold. During that time itself, she was an anchor in the radio. She did multiple tasks at a time. And this person is a very sober person. It was a total mismatch. And the very fact that the petition is pending for 20 years without any efforts of each other to file even a reconciliation petition, Section 9 petition or anything saying that I would like to come back from the wife's side also, or the daughter trying to visit the child. Nothing of that sort has happened, please, Your Lordship.
But the act does not provide for. But the act does not provide for giving a divorce on the ground that the couple there is a mismatch in between the couple.
My lords, there is one decision which Your Lordship is aware that Justice Mohan Shantan Gowder has passed on 8th December 2015, please, Your Lordship, wherein pendency of a case for so many years would not result in anything. And based on that decision, it would be possible for, and keeping this petition or this marriage alive also would serve no purpose except that both would be called as husband and wife and nothing other than that, please, Your Lordship.
At least for the sake of the child, they have to continue.
My God, that is the reason I'm telling the father and the child have not even spoken to each other, please, Your Lordship.
Nobody has prevented you, madam.
No, it's not like that, please, Your Lordship. For me to say
You are
that
not
they have
interested.
they have
You are
developed
not
a
interested in
relationship.
your child. What
Pardon,
typical? You are not interested in seeing your child.
My client, he feels that once they start visiting, they start saying there will be a relationship that would develop and that would result in so many other pains. So it is better I be
You
like this.
you don't want the relationship to develop.
My lords, he has gone astray, in fact, please, Your Lordship, except that he has not taken sannyas. He has gone astray. He doesn't have anybody in the family. That is, all are settled in their own way. He is living alone. He is working in a printing press and he doesn't have much income also. That also the petitioner, the respondent is aware. After breakdown of the marriage, he has gone astray. He had a lot of expectations from the marriage. They had come from, both are from a very religious background. Both are from a very cultured background. And what is making them to part from each other, I'm not aware, please, Your Lordship, because the respondent at no cost, she says, I will not give divorce. If not, we could have gone for a consent divorce long back. And most of the time, even if she's present before the court, she says, I will not give divorce. I do not know what is that she's getting out of the having this relationship also. I don't understand.
Yes. Any other? Past reasons we are dismissing your appeal.
Much obliged.
The last posted.
Our problem is that supposing if we pass an order, they will file an application for recall on the ground that it has been passed in violation of principles of natural justice. Do you understand? That's our difficulty. So and so learned counsel, the appellant none for respondent, getting appearance of learned counsel, hearing of the appeal is deferred list after ensuing summary.
On behalf of the respondent, my lords.
For appellant is not there, madam. Why did he appear? So we have no problem. Hello, why we should sit for this case only, madam? Not tomorrow, madam. Only 2 days are left. We have our hands full. Don't be under any impression that we are not working.
Number 51, CH-2.
Yeah, but just after entering we to look at.
The Narayan Reddy, the Ujjwala A. Mandi.
Same on.
On behalf of the respondent, my lords, in this matter.
Is the respondent. Not Mantigi. Yeah.
The R. Gopal, the Revana Bellari.
Yeah. That is marker presence, learned senior correspondent, awaiting appearance, hearing deferred, list after entry. Or was passed in your presence, right? You didn't say anything. Oh, you don't know. You know what is the combination after vacation? You, huh? No, you know that we don't know. Huh? Team order? Which interim? See if there is an interim order.
Yes, yes.
If asked and not happy, you have the remedy of going to Supreme Court. Right? Please file challenge that order in SLP. If you are not happy, what can we do? Order has been passed.
Registrar, this combination is, you want this matter to be listed before the very same combination which I had heard it earlier. It is for the registrar to constitute a bench. We cannot give a date. Unless after vacation, know whether we are sitting, therefore we cannot give a date.
We close it at 1:30 and
Easy.
close it.
How can I close the door? Why you tell that?
Yes, ma'am. I have already instructed all the bills. Yes.